Hey, this Honorable Court of Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Good morning, counsel. On behalf of Judge Arnold Golden and Judge Kenny Armstrong, I welcome you both to this virtual oral argument, which will be conducted in much the same fashion as we would be in court or would have done in court. I want to remind counsel that we'll be live streaming, or this argument is being live streamed, so that we can fulfill our obligations to keep the courts open, despite the fact that we've gone virtual. If there's no preliminary matters, I'll ask the clerk to call the case.
Daysparkles Oliver versus Tennessee Department of Safety and Homeland Security.
Mr. Monsieur, I think you're the appellate in this case, and have you reserved some time for rebuttal? You have, I see, and that request is granted. So we'll hear from you.
The appeal in this case is a judicial review that got split up in the Chancery Court to do two different judicial reviews. But the department took a judicial review and contended that the administrative judge did not establish standing, and the chancellor.
And Mr. Monsieur, there's cash involved here, but there's also two vehicles. Is that correct?
That is correct.
And is your client the title owner of the vehicles, or does she have a security interest in them?
She is the title owner.
So I am confused about why standing would be an issue with respect to the two vehicles.
Well, the administrative judge found that she was the owner of the two vehicles. She was also the owner of the residence where the currency was seized from her bedroom. And I thought that the administrative judge had established standing, but nevertheless, the chancellor below disagreed and remanded it back to the administrative judge to determine standing under the more recent case of Tubbs versus.
Well, and I can understand while in Tubbs, and maybe I should ask you this and reserve the question for the state on the vehicles. But with respect to the cash, appreciate the cash was found in your client's residence. What's her claim to that cash?
Her claim to the cash is that
yes, sir.
It was her currency.
How so? I mean, was it earnings? Was she asked to hold the funds as a bailee? What does the record tell us about that?
She had collected funds for a specific. Frankly, there was no evidence below offered on that.
I see.
So I'm reluctant. What I say is outside the record with regard to the currency. There is a statute, however, and the statute's 4033 204L that says there is a presumption that currency is not subject to forfeiture, and that presumption must be rebutted by the department. So the presumption, I suppose, is the only thing that is in the record.
So, in that, I guess by that argument, you're suggesting the court really should, Todd's wrong, and we should address that presumption initially before getting to the standing question.
Well, I think it is part of the standing question. It is also part of what needs to be done on remand. In this case, the department claims that Ms. Oliver is required to establish that she is an innocent owner under 53-11-451 F1A and B. That is, that she acquired the property in good faith, number one, and number two, that it was not to be used in any drug violation. The administrative judge said that there was no nexus between the currency found and an illegal drug transaction. The problem, though, that is raised on the standing issue is by the department saying that the initial burden is on Ms. Oliver to establish that she was an innocent owner, which we believe was rejected by the Western District in the Tennessee Walking Horse 2 that we have cited, and is an impermissible shifting of the burden of proof to Ms. Oliver.
Was the forfeiture in the Walking Horse case under the same statute?
No, sir. It was under a different statute.
Well, doesn't that make a difference then about how we should approach those in the administrative level?
It certainly is a matter that could be used in the statutory construction in determining whether that case is distinguishable. If I could move on very quickly, I've addressed the tubs. It's our position that if the remand for standing on any portion of the case is affirmed by this court, if the chancellor standing, then the whole case should be remanded. The administrative judge cannot then pick and choose and consider interlocutory matters if the case is back on standing before the administrative judge. Otherwise, it would have to comply with the provisions of Rule 54.02 as being an interlocutory matter, or the second sentence of 45322A1 that provides for a decision on judicial review of an interlocutory matter. The other issues, unless standing was obtained, are interlocutory and should not have been decided by the chancellor. The chancellor also held that our written notice of our judicial review of cases and of the request for attorney fees was not a petition under 45322A1 for judicial review. I'm not quite certain what she believed should be done in addition to the statute, but we believe the Sherwin-Plow case clearly holds that a notice for provisional for judicial review requires only two elements. And it is equated to a notice of appeal in this court. And we believe that the chancellor erred in holding that the written notice of judicial review that we filed and we cited was filed under 4033-213A as being notice of judicial review was sufficient to obtain judicial review in the other case that's now been consolidated in this case. With regard to the search warrant.
Here, before you leave that issue, can I ask you a little bit? So what's the harm with the dismissal of your provisional notice there in this case? I mean, since the state did appeal, do we really need to reach that issue? Because it sounds like all the issues are going to be back before the administrative judge under the relief you requested with respect to the state's notice of appeal. So what's the harm here? What are we trying to correct on the issue of the dismissal of your notice?
Well, first of all, she did not consider any of the issues that we had tried to raise. And once again, that goes to whether or not there is a final judgment in this case or in that case. And if there is not a final judgment as defined in 45314C, if there's not a final on all aspects of the case, then she's to remand all aspects of the case, including those, back to the administrative judge.
And I'm assuming one of the issues, or not, I'm not assuming based on your brief, no, is the question of attorney's fees.
Certainly.
And so on attorney's fees, I'm a little confused based on the briefing here, when the request for attorney's fees was made on behalf of your client.
it was made after the administrative judge had ruled in her favor. The application was made. Under the Belanga opinion, a request for attorney fees is not right until after the administrative judge rules in favor of the plaintiff. There has to be a contested hearing first. And we did file the motion for attorney fees after the favorable ruling.
And is that motion in the administrative record?
Yes, sir. Yes, sir. With regard to establishing and docketing a case, very, very important issue that we've raised. I'm out of time, but the department in this case does everything internally. They don't serve with regard to establishing a hearing date. They don't serve it on anybody, the defendant, their attorney, or any of the administrative judge as required by the regulations. Then they put down a notice of a hearing that just goes to that one case that was not in the record at the time the administrative judge reviewed this case. And that notice of hearing is not served on the administrative or judge as required by the statute, but it's all internal up until the time that the department actually serves a copy of the notice of hearing and it gets put on the docket. The docket is a published document by the Secretary of State.
Right. Mr. Monsieur, you're out of time, and I know I've taken a great deal of it, so I gave you a little leeway going over there to make your final point about the docketing, but you'll have your time on rebuttal. Ms. Jones.
Good morning, Your Honors. I am Miranda Jones. I'm with the Attorney General's office, and I'm representing the department in this case. There, as you all touched on, there are really only 3 issues that need to be resolved today. The first, that the Chancery Court had subject matter jurisdiction over the petition for judicial review filed by the department. Second, that the Chancery Court lacked subject matter jurisdiction over the provisional notice of review filed by Ms. Oliver. And third, that remand is appropriate on the matter of standing. With respect to the department's notice of petition for judicial review, the court had subject matter jurisdiction over that issue, and the court specifically considered the issue of subject matter jurisdiction relative to whether there had been a final order issued in the administrative proceedings below. The court found that the order was final for a number of reasons. First, simply on the facts of the case, the only thing pending before the administrative law judge when it issued its order was the final briefing in the case. And in that final briefing, that was a post-hearing brief, by the way, Ms. Oliver asked for permission to file a request for attorney's fees. The administrative law judge ruled on all pending matters and implicitly denied that petition by not addressing it. And that is sufficient to say that the order was final. Any of the other pending matters that
you're saying there's actually no motion in the administrative record, rather there's a request for leave to file a motion.
At the time that the administrative law judge issued its final order, yes, Your Honor. After the order was issued, the department petitioned for judicial review of the order, and the Chancery Court held that alone was sufficient to show that this order was final. In addition, this is a very important part, Ms. Oliver moved both in the department's petition for judicial review and in her own notice of provisional review case for return of her property. The Chancery Court had a hearing on that matter on November 20th, 2018. And at that hearing, Ms. Oliver's attorney agreed that the order was final so that Ms. Oliver could receive her property because the department had not moved to stay the administrative law judge's order. So as a result, since there was no
transcript of the hearing is in the record.
Yes, Your Honor.
Okay.
Since there was no motion to stay, and Ms. Oliver's attorney conceded that any pending matters were either moot or waived, that allowed the court to say this order is final on independent grounds. Aside from the fact that it was final, we even had concession that the order was final so that Ms. Oliver could receive her property. And consequently, any matters alleged to be pending before the court to be pending before the ALJ that might deprive the court of subject matter jurisdiction were moot or waived. That's why the court had subject matter jurisdiction over the department's petition for judicial review. And for the same reason, the court lacked subject matter jurisdiction over Ms. Oliver's provisional notice, because the only relief sought in that provisional notice were the matters that Ms. Oliver had just conceded were moot or waived. There are separate grounds for finding that the court lacked subject matter jurisdiction over the provisional notice of review listed in our brief. Those include that the provisional notice of review was a conditional document, and the rules and statutes in place don't contemplate conditional notices that depend on future events before they take effect. It must be a petition or not a petition. It can't be a halfway petition. If something happens, then it's a petition. That takes care of the subject matter jurisdiction issue, which allows us to get to the issue of standing. Here, the administrative law judge did not require a standing determination. And as this court addressed in Tubbs, threshold requirements, principles of justiciability require standing for the court to have, for the matter to proceed. Ms. Oliver had to show that she
So
had.
what do we still need to find out about standing with respect to the vehicles?
With respect to the vehicles, we agree that there is undisputed ownership interest. The cash, however, we argue that there is not sufficient or any evidence presented or even credible testimony presented to show that Ms. Oliver had ownership of the cash.
I mean, it strikes me that if this just involved the two vehicles, the standing hearing is going to be nothing. It's Ms. Oliver is going to stand up and say, of course, I was not involved in any of this, and my name's on the title. Doesn't that basically establish her standing?
Your Honor, we agree. Her name being on the title certainly establishes standing as to the vehicles, but it does not establish standing as to the seized $23,000 of currency.
And I'm trying to think about economy of judicial resources here. So we're sending it back because one element of her overall claim to property did not address standing. Yeah, I guess standing is not addressed in part, and that's why we're sending it back.
Yes, Your Honor.
Okay. And it seems like we'll probably be right back where we started in a matter of months.
Potentially not, depending on how the administrative law judge rules on standing. The Chancery Court's opinion certainly resolved many of the remaining matters, but there are also other matters that formed the basis of the remand, not just standing. There had to be a finding of fact as to the propriety of Ms. Oliver's claim for, I believe it was the Chevrolet Impala. The paperwork and matters at issue there had not been properly ruled on by the administrative law judge. So there are certainly other matters for the ALJ to consider. But in the absence of established standing, we argue that that the Chancery Court's determination was correct, a remand is appropriate. And this court doesn't need to consider anything else until standing is resolved. However, if the court has any questions on the remaining issues in this case, I'd be happy to address them.
Seeing none, thank you, Ms. Jones. Mr. Monsieur, your rebuttal, please.
Well, just a moment. Let me unmute here.
Oh, you just muted yourself instead of unmuted.
How's that?
That's great. Sounds good.
If I understood what Ms. Jones just said, she said that the court doesn't reach anything else until standing is established. Well, that's my point. My point is that the Chancery Court did not have jurisdiction to reach anything else until standing was established. And by the Chancellor's ruling, she ruled that there wasn't a final judgment by the administrative judge. And with regard to the cars, she further ruled that the Chancellor didn't make a specific ruling with regard to the cars. So my point is that she did not have jurisdiction, according to her own order, that to rule on anything else in the case, just like Ms. Jones has said to this court, you don't need to rule on anything else until standing is established.
So your fault with the Chancery Court's decision basically is once they addressed standing, once the Chancellor addressed standing here and determined it was wanting, should have stopped right there and just sent it back.
Yes, sir.
Okay.
That is correct. And secondly, the Chancery Court the Chancellor did go forward, and the Chancellor ruled on two issues that at that time would have been interlocutory because there had not been a final decision under 45314C on all aspects of the case. And so the Chancellor, once it was ruled that way, she went forward, ruled on two other issues, that is the search warrant, and ruled on the question of whether or not the notice of seizure had been complied with, and reversed those two when in fact she didn't have subject matter jurisdiction to do so. Further, two other issues that she ruled on that she remanded back. One of them is to whether the affidavit for the forfeiture warrants were sufficient under 4033-204 B1. She remanded back that the findings weren't sufficient. So once again, there wasn't a final decision. So I agree with Ms. Jones when she says, in part, because the Chancellor ruled that standing hadn't been established. And by the way, the department has not appealed that ruling.
Well, I mean, Mr. Monsieur, you know, based on my questioning of Ms. Jones, that I'm concerned about judicial economy here, and it seems like your approach would result in piecemeal appeals, right? Because you're saying stop at standing, send it back for that. The ALJ addresses standing, assumes that all the other rulings have sufficient foundations, and it gets appealed again. And then what then? On the next appeal, they address the Chancellor then addresses the decision on warrant. I mean, isn't that what we're supposed to do as a reviewing court, is to give some clear instructions so perhaps the parties can resolve it at the trial level or administrative level in this case, and not have to come back to us?
Well, it's going to come back to you all, I think, either way.
Now, Mr. Monsieur, I need you to be more optimistic this morning.
Well, if let's assume that the administrative judge rules in our favor. The department has. And
the department may see the error of their ways and say, you know what?
Well, they've gone through a scorched earth attempt for the last 6 years or 5 years, however long it's been. And I don't anticipate that anything's going to change with regard to that.
Mr. Monsieur, you've joined them in battle too. So
well, yes.
It's been on both sides.
But then if that's the court's ruling, that the ruling on the search warrant is going to be binding back on the administrative judge, then we need to review the ruling on the search warrant as to whether or not the Chancellor erred by failing to consider matters outside the affidavit of complaint to impeach the search warrant complaint.
Mr. Monsieur, thank you. Your time has expired. I have to thank counsel for both parties. The case is submitted. You may now leave the Zoom meeting.
This honorable court is now in recess until 11 a.m.
Sorry, Mr. Hibner, I should have just said do your job.